Judgment has been reserved in the matter brought by a South African Human Rights Commission to the Constitutional Court. The Chapter 9 institution filed papers to appeal the recent judgment of the Supreme Court of Appeal. The Commission is seeking a ruling that its directives on human rights violations are binding in certain instances. To talk more about this, we're now joined by Commissioner of the South African Human Rights Commission, Nomahlubi, Khwinana. Nomahlubi, thank you so much for your time this evening. Really do appreciate it. Outline for us where the demarcation would be in the imagination of the South African Human Rights Commission about where the limits of its binding powers would be and in what instances.
Thank you so much, Oliver, for having me this evening. At the heart of it, Oliver, it is that as Human Rights Commission, we are the custodian of protecting, promoting and monitoring human rights and the culture of human rights. And how we do it is that we are supposed to take steps in order for us to obtain redress. Now, in this case, in particular, it was the right to water that Mr. Dukusi needed to have since 2016. His rights were being violated. And we then made a directive or a recommendation that water, his right is being violated with regard to his right to water, which is enshrined in terms of our Constitution, Section 27 in particular. And unfortunately, the matter went to court. That was the High Court first in Mpumalanga. But the court said that we can't be ignored, but our recommendations are not binding. Now, what then it means is that once, yes, we can't be ignored, but similarly, Mr. Boshoff can just still not realize that right for Mr. Dukusi in order for him to have the water, which has been ongoing since 2016. So you can imagine if we are going to allow this to persist and without challenging it, it meant that we would not really have a solution to this because what impression has been created is that as Human Rights Commission, anything that we direct to be done is not legally binding. So which means that anyone can then not do anything about it, which then says we must go to court and try and force these orders. This is going to take our resources and really a lot of time, whereas the right to water will continue to be violated.
Yeah, I understand the rationale about why that power should exist. But in the court, the argument that the South African Human Rights Commission made in court isn't why that power should exist, but rather that the power does exist. What would be the legal precedence, if there is any at all? Perhaps we could look at what happened with the Public Protectors Nkandla case for some legal precedence, or on the other hand, what would be the legal authority, perhaps located somewhere in Chapter 9 of the Constitution, about the fact that the power might actually currently exist?
Well, one would have to look at Section 184, subsection 2B, wherein it says then that we can take redress or steps in order to obtain redress. And you cannot read that in isolation without going further to Section 15, which also then, Section 13, subsection 3, which then again defines our powers. So all this have to be taken into account. But similarly, what we are saying is when you talk about the recommendation and taking steps in order to obtain redress, for us, it's a question of semantics, if one can put it that way. If you look at the public protector, it says a remedial action. And if you're going to look at maybe the dictionary meaning, you might say that maybe that has more power. But where we come from is that that's not what it says. In fact, for us, our powers powers are wider than understood by anyone else. The court, in fact, that is our argument.
Isn't this rather the resolve of lawmaking, in that members of parliament just need to actually write the law that gives the South African Human Rights Commission that power explicitly, rather than having to conject it through different pieces of legislation?
Well, unfortunately, a confusion has been created as a result of this matter, which, as I said, it starts from the High Court in Mpumalanga, where the court pronounced that we can't be ignored, but they are not legally binding. And unfortunately, even SCA said the same thing. Now we're in the Concord. Now it is for the court to give a proper interpretation of the law. Yes, it is so that the legislature will draft the law and of course will pass the law. But at the heart of it, it is still upon the courts to bring the proper interpretation into the law. And this is where our counsel has tried to ensure that the courts understands where we're coming from with regard to this matter. But of course, at this stage, Oliver, we can only wait and see how the court is ultimately going to be able to interpret this.
Yeah. Commissioner Nomahlubi Khwinana, thank you so much for your time this evening. Really do appreciate it. That is a commissioner of the South African Human Rights Commission.